Court calls the case, People versus Delorean Dur.
Before a single name is called, this docket already tells a story about pressure, priorities, and how quickly lives pivot inside a courtroom. Today isn't about one dramatic verdict. It's about a conveyor belt of defendants, each carrying their own version of risk, responsibility, and consequence. Watch how Judge Simpson manages time, credibility, and control. Notice how attorneys frame their clients: stability, jobs, family, treatment. These are not casual details, they're strategic lifelines. Bond decisions here aren't symbolic. They determine who sleeps at home tonight and who doesn't. This session also shows something the public rarely notices: how much hinges on paperwork, discovery, and timing. A missing video, an unsigned order, a claim that paperwork was never received. These aren't technicalities, they're fault lines. When those cracks appear, judges look for one thing above all else: truthfulness. As we move through these cases, pay attention to patterns. Who gets patience and who doesn't? When does the court lean toward caution over compassion? And when lawyers speak, ask yourself, are they explaining or are they excusing? Because in this courtroom, credibility is currency, and once it's spent, there's no refund.
Joseph Ignaldo, people, Your Honor.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Duhall. Mr. Duhall, could you please state your name for the court?
Delorean Dur.
Apologize. Your Honor, two things. First, I had spoken with Mr. Dural about setting this for exam, but in reviewing the discovery after we spoke, I realized that there's some more discovery that I would need before setting it for exam, so it's not there quite yet. I still have to fill out a green sheet for Your Honor, but I'm asking for a short adjournment to do that, please.
August 28th, 2025, 9 a.m. I'll need a green sheet. Bond will continue.
Judge, I was hoping to address bond for Mr. Dural. Your Honor, Mr. Dural suggests that he has a number of community supports and stability in the community that would allow him to be monitored safely. He does live with his father in Southgate. His father is a business owner and he works for him. He is being groomed to take over a management position there, and he's made a lot of strides there. He also works full-time at McDonald's, 10 to 6 weekdays, Your Honor, and he has a 4-month-old baby at home. He is asking the court's consideration for bond review.
Response.
Bond is appropriate to see charges.
I'm sorry, I did not hear any of that last part.
I believe, Your Honor, the bond as set is appropriate to the need of the charges that I'm facing. But only of this criminal history. But given the fact that this defendant is charged with armed robbery, I think the bond is appropriate as set. People for the court's to make further determination.
At this point, what I'm going to do is I'm going to deny the motion to modify the bond in this case. The bond will continue. However, Mr. Bernstein, if you'd like to file a written response so I can get more information, since I didn't get any for the people, I'll be more than happy to consider it.
We'll do that, Your Honor. Thank you.
Court does call the case People versus Tesa Michael, Tesa Miriam.
Joseph Ignaldo, people, Your Honor.
Good morning again, Your Honor. James Fifelski appearing on behalf of Mr. Tesariam, who is approaching. Come on up, sir. Please state your judge.
Tesa Michael Tesa.
I'm sorry.
My name is Tesa Michael Tesa.
Your Honor, we are simply asking the court to set this for preliminary examination. I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from community corrections, I advised him to go over there. He said he did go over there twice yesterday, asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
That's not true. There's
Okay.
paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have sent the bond violation. He's not telling you the truth.
I did quote.
This is where the temperature in the room spikes. When a judge openly challenges a defendant's version of events, that's not a misunderstanding. That's a credibility crisis. Judge Simpson isn't speculating. He's referencing paperwork in real time. Community corrections doesn't schedule violations without records, and the judge makes that clear. Language barriers and confusion can be real issues, but courts still expect compliance. The defendant claims he tried, twice, to enroll. The judge says the paperwork exists. That contradiction is fatal at this stage. Once the court believes a defendant is minimizing or misrepresenting facts, leniency evaporates. Notice how quickly this shifts from explanation to consequence. The bond isn't adjusted, it's revoked. This isn't punishment, it's containment. The judge is signaling that supervision only works if the defendant participates honestly. Engagement question. When someone claims confusion versus noncompliance, where should the court draw the line? And how much responsibility should fall on the defendant to prove effort?
Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing hit for him to do.
When did he say he went over there? Because I'll call right now.
You said that.
Yesterday afternoon?
They wouldn't have. It's not true.
I did.
I can tell, because I've got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Court does call the case People versus Carlos Sell.
Albert, hearing on Mr. Self, who's approaching the podium as we speak. Carlos, once you get up here, please introduce yourself to his honor.
Carlos Sell.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28th, 2025, 9 a.m. Bond continued.
Thank you, Judge. Defense may be heard as to bond.
Go ahead.
So, Your Honor, Mr. Self had previously received a bench warrant in the case ending in 5140. That's because he was in the hospital with extremely high blood pressure. He tried to leave. He tried to get his doctors to let him go, but the doctors said, well, you can stay here or you can go to court and have a stroke due to his extremely high blood pressure. So he opted to protect his health and stay. So unfortunately, he was predisposed. He did have his intake paperwork. I asked him to provide it for me, but unfortunately that was lost when your apartment flooded, was it?
Yeah.
So his apartment flooded and destroyed a lot of his belongings. So unfortunately, we don't have documentation for the court. He is also interested in.
Does that explain the cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Here we see the court wrestling with sympathy versus substantiation. The defense presents a compelling personal story. Hospitalization, extreme blood pressure, a flooded apartment, lost paperwork, employees depending on the defendant's business. It's human, and it's relatable. But the judge stays anchored to one reality. None of it is documented in a way that offsets prior failures. Courts don't dismiss hardship, but hardship doesn't erase procedural history. A bench warrant already exists. Substance use is mentioned. Treatment is discussed but not completed. Each unresolved issue stacks weight on the scale against release. Judge Simpson's ruling reflects a balancing act. He doesn't escalate punishment. He simply refuses to reduce restrictions. Bond remains unchanged. That's restraint, not indifference. This raises a critical question. At what point does explanation become pattern? And how many unfortunate circumstances can a court reasonably absorb before credibility collapses?
Court does call the case of People versus Vincent Lambert.
Morning, Your Honor. Public Defender Lemmy Saab on behalf of Mr. Lambert.
Mr. Lambert, can you state your name, please?
Vincent Lambert.
Thank you, sir. What are we doing?
I'm requesting an adjournment. Your Honor, we are missing some video. I did re-request it yesterday, and as of this morning, Mr. Childers did advise me that it should be released, so we just have to extract it and watch it.
Give you my next available date, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
What was your name,
Thank
ma'am,
you.
so I can call you and ask you a question?
He's talking to you.
It's Miss Saab. Like the car, S-A-A-B.
Ms. Saab, thank you very
Saab,
much.
not Audi. Trying to make that clear. Court calls the case, People versus William Bastable.
Sorry, Your Honor. Assistant Public Defender Ben Dunawith on behalf of Mr. Bastable. Your Honor, the defense is asking to adjourn a week. We've not received the video discovery. My emails of Friday and Monday were not returned. We cannot conduct the preliminary exam without the video that is referenced in the police report. So we'd ask to adjourn for a week. I do have the form in my bag.
Well, I'll need the form.
Okay.
Without objection, probable cause conference, August 28th, 2025. 9 a.m. Bond will continue.
This sequence illustrates how quiet cases move quickly. No objections, no credibility disputes, no missing steps. When both sides agree and the process is clean, the court advances the case efficiently. Bond continues not because of sympathy, but because nothing triggers alarm. These moments rarely go viral, but they're the backbone of courtroom function. Judge Simpson rewards preparation and cooperation with predictability. There's no lecture, no warning, just progress. It's a reminder that in court, drama isn't always loud. Sometimes the absence of conflict is the strongest signal that everyone is doing their job correctly. Viewer question: do cases like this restore confidence in the system? Or do they fade into the background because nothing explodes?
Court does call the case, People versus Tanya Hall.
Good morning, our object on behalf of Ms. Hall. Tanya, state your name.
Tanya Hall.
Judge, I've just been speaking with the prosecutor in this matter. I believe we're going to work out an agreement where she's going to be allowed to plead to a misdemeanor. My understanding, we don't have a plea form today, so we're asking for a very short adjournment so we can do that.
Has she been counsel approached?
I believe we have a plea worked out. We need to do the paperwork. We're asking if we could set this matter to the 28th.
All right. I will adjourn this matter out August 28th, 2025, 9 a.m. Bond continued.
This is one of the few moments where you see the system pivot toward resolution instead of escalation. A negotiated plea to a misdemeanor is already on the table, and Judge Simpson's role here is not to interfere, but to ensure the process is clean. No plea form means no plea. Paperwork matters more than intent. What's important is what doesn't happen. There's no bond increase, no warnings, no skepticism. That tells you the court doesn't see immediate risk. When a case is trending toward a negotiated outcome, judges prioritize stability. Keeping bond in place maintains leverage without disruption. This also highlights how much of criminal court is administrative. Outcomes are often decided long before the final hearing, but they only become real once the paperwork catches up. Audience question: should courts push harder to finalize plea deals faster, or is caution the better safeguard against rushed justice?
Okay, Ms. Hall, we'll see.
Yes, sir.
You got it back on the 28th.
Yeah.
That's you. Okay.
Court does call the case, People versus Brian Gerard.
Joseph Delorean Dur.
No. Assistant Public Defender, let me stop on behalf of Mr. Gerard. Your Honor, we are asking to set this for preliminary exam, and to my knowledge, discovery is complete.
All right, sir, your name?
Brian Gerard.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Court calls the case of the People versus Ronald Lucky.
Joseph McCann, Your Honor.
Judge, in this matter, we'd like to set this matter for a preliminary exam.
Your name, sir?
I'm Ronald James Lucky.
Discovery is complete, Mr. Kidwell.
Yes, Your Honor.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him. He was renting a space at 1074 East Forest. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that.
Judge Otis
Well,
ordered it in writing.
who ordered it?
The one that let me out on bond, I believe Judge Otis, they wrote it down on a
No,
post, you know.
It's a Odetella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
I'm sorry.
Funny.
Right.
Right. Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Killowell, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
This exchange is deceptively important. Property access disputes may sound minor, but they're often the difference between someone restarting life or spiraling further. Judge Simpson doesn't dismiss the defendant, he redirects him. The court is clear: no order, no action. Judges don't enforce promises or Zoom statements. They enforce written orders. By offering to sign immediately, Judge Simpson shows flexibility without abandoning formality. He's not blocking relief, he's demanding it be done correctly. Timing is critical. The judge even warns that if it's not done today, it won't happen for a week. That's a subtle but firm nudge to counsel. Move now or lose the opportunity. Engagement question: should courts be more proactive in helping defendants recover property, or does that cross the line into advocacy?
Okay.
Sure.
All right.
Nothing.
Huh?
Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'd have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court
Wait a minute,
keeps me
hold on.
on my, that address.
Okay, we're gonna take care of it.
September 2nd.
Yeah. September 2nd.
Court call stays. People versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gabachi.
Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second.
That's fine, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fresh Hour. Bonds will continue.
Your Honor.
Court calls case People versus Ashley Nader.
People, Your Honor.
Morning, Your Honor. Rob J. Kill on behalf of.
Actually,
Judge, in this matter, we're asking.
Your
that-
name, ma'am.
Ashley Nader.
Thank you.
Nader, I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Kilowog?
Judge, I'm not sure where I am this morning.
Okay. All right. Well, that leads to confidence for your clients. Come on.
He wants you to go take ETG, see if you got any alcohol in your system.
All right. In essence, you're seeking an adjournment of these.
No, we're setting preliminary exam.
Exam. All right.
Hold on, just relax.
People would have their witnesses available tonight.
The ninth.
Preliminary examination in this matter will be set in person September 9th.
Judge, I'm sorry to interrupt you, but I have probate matters, 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're going to go in probate court. It's over money issues. I think they're going to be long hearings. Can we go out? Is it possible?
Doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're going to be going when?
To the 8th, 3rd.
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're going to go test. You're going to take that.
What I'm going to do is I'm going to order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post it in the fashion those are posted. You need to go over and take an ETG test. I'm also going to order that the defendant is to be placed on a sober link unit pending further order of the court. Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed in silver link in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays.
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan. And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a tether.
This is one of the strongest judicial warnings of the day. Judge Simpson lays out the violations clearly: alcohol concerns, social media behavior, unauthorized travel. And yet, he stops short of jail. That restraint is deliberate. Instead, the court tightens supervision, ETG testing, silver link monitoring, tether remains. This is graduated response in action. The message is unmistakable. The next violation won't be met with patience. What's striking is the judge's transparency. He explains exactly why incarceration didn't happen and why future leniency may not exist. That clarity removes ambiguity and excuses. Viewer question: is electronic monitoring an effective second chance or just a delayed consequence?
Anything else?
No, Your Honor. Was she supposed to report back today after the
No,
testing?
she doesn't need to report back today. She needs to go over and take the ETG test. Well, there'll be an order over there and she needs to pick up her sober.
Okay, thank you, Your Honor.
Court calls case People versus Khalil Haddon.
Joseph Engelman, people, Your Honor.
And Assistant Public Defender Lamis Saab on behalf of Mr. Haddon, who is approaching. Mr. Haddon, if you can say your name for the record.
Kahil Jabron Haddon.
Okay, go ahead.
Your Honor, discovery is complete in this matter, and we would be requesting to set it for preliminary exam.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
That's in person. Thank you. Bond will continue. Court calls the case, People versus Curtis. Is it Moncanito? Moncanico?
Joseph Engelman, people, Your Honor.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Mechanical. Sir, could you say your full name for the record?
Curtis Mydro Mechanical.
Step a little bit. Thank you. And Your Honor, we are requesting just a very brief adjournment. We haven't yet received discovery on this file. Our support staff reached out yesterday to the prosecutor's office, and I believe we should be getting that very soon.
August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Thank you. Court calls the case, People versus Derek Lovely.
Joseph Engelman, people.
Brandon Bird on behalf of Derek Love.
I was wondering where you were. It was not going to be a complete day unless you showed up.
I was thinking the same thing about you, you know.
Your name, sir?
Derek Lovely.
Thank you. All right, you're asking for an adjournment.
Please.
4th or the 11th, sir?
I'm the 4th, please.
4th. Probable cause conference will be set September 4th, 2025, 9 a.m. Bond will continue in this case.
You and your Honorable Court have a great day.
Thank you. You too. Court does call the case of People versus Michael McLean.
And on behalf of the people.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. McCann, who's approaching. Could you say your name for the court?
Michael McCann.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is I don't think there's any outstanding discovery.
People have their witnesses available the second.
We'll do our best, Your
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any like bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her and not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Ender, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property. When she would come outside, he jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction from 2007 and 2022 dismissed home invasion first, a 25 dismissed PhD second, and malicious destruction of a building,
And he currently does have a hold on his insurance for a domestic violence case with bond set at $500. But at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it did.
HPA.
You were being zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I can clarify, I'm not sure exactly it's arrested. If I can clarify, he went to the residence on 528, was served the PPO that day, and then in the preceding days after he was served the PPO and told he should not be having contact, he went back to her property and then was also calling her. So he was violating that PPO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court is this is not a hearing date, so I know we can't get into the details. The missed call login discovery shows 528 and not after. So we dispute that he made any contact with her after being served the PPO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue.
This final bond decision is rooted in safety, not sympathy. The prosecutor details prior conduct, alleged violations, and a troubling history. The defense attempts clarification on timing, but Judge Simpson doesn't litigate facts today. He evaluates risk. This isn't a trial, it's a snapshot. And in that snapshot, unresolved disputes plus past conduct equal continued custody restrictions. The judge explicitly acknowledges that these issues belong at the preliminary exam. Until then, the status quo remains. This ruling reinforces a core principle. Bond hearings are not about proving innocence. They're about preventing harm while the case moves forward. Audience reflection. Should disputed facts ever favor release, or does uncertainty itself justify caution?
Thank you.
Thank you.
This docket captures the quiet power of courtroom decision-making. No verdicts today, but dozens of lives shaped by bond rulings, adjournments, and credibility calls. Judge Simpson consistently applies the same lens: preparation, honesty, and risk. When lawyers come ready, cases move. When facts conflict or paperwork is missing, consequences follow. Across these cases, one theme dominates. The system rewards clarity and punishes uncertainty. Bond is preserved when compliance is shown. It's revoked when trust erodes. Supervision tightens when warnings are ignored. None of this is arbitrary. It's incremental, procedural, and deliberate. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns from Trial Truth.